Special Counsel Jack Smith and his team of prosecutors are aggressively pushing forward with the Washington, D.C. federal criminal case against Donald Trump as Donald Trump lashes out, whines, and complains that he wants the Washington, D.C. criminal case to be entirely stayed or halted pending his notice of appeal on the denial of his motion to dismiss the indictment on absolute presidential immunity grounds. I'm Ben Meiselas. This is the MeidasTouch Network. So earlier in the day on Tuesday, Special Counsel Jack Smith filed a government's notice regarding CIPA Rule 6 hearing. Here it is right here. Government's notice of filing. The government hereby gives notice that on December 12th, 2023, it filed with this court, referring to the Washington, D.C. Federal Criminal Court, through the Classified Information Security Officer, CISO, a pleading titled Government Motion for CIPA Section 6A Hearing. We've been following CIPA procedures here on the MeidasTouch Network. Don't get sick of it. It's really important. In cases involving classified information, the same way the Mar-a-Lago federal criminal case of Donald Trump's willful retention of national defense information clearly involves classified information, so does the Washington, D.C. federal criminal case to a limited extent, and you have to go through some of the procedures of CIPA, Classified Information Procedures Act. Remember, CIPA Section 3 is the protective order. CIPA Section 4, government withholding certain documents that are so highly sensitive, and then you are requesting a substitution in its place. CIPA Section 5 is the criminal defendant states the documents that they want to introduce at trial that may be classified in nature. CIPA Section 6 is a hearing with the judge where the criminal defendant and their lawyer is not present, where a determination is made about the type of substitutions where a document is highly classified. You replace that document with a substitution. So here, Special Counsel Jack Smith's basically saying, look, we don't care that Donald Trump filed a notice of appeal regarding Judge Tanya Chutkan's December 1st order denying Donald Trump's motion to dismiss the criminal indictment in Washington, D.C. based on absolute presidential immunity. Jack Smith saying under the Griggs doctrine, sure, some aspects of the Washington, D.C. case may be stayed. Those that fall within the province, those that are within the scope of the order being appealed, but that just relates to the issue of absolute presidential immunity. We're going forward with all the other proceedings. Donald Trump's responding and saying, absolutely not. Special Counsel Jack Smith, according to Donald Trump, the law states, and a new Supreme Court case that came out in June of 2023 called Coinbase states that the district court proceedings get stayed or stopped pending a notice of appeal on a dispositive issue like immunity. The case that Donald Trump asserts for that proposition, it is a case called Coinbase involving a denial of a motion to compel arbitration. The Supreme Court held the issue of arbitrability is a threshold matter, and thus when a interlocutory appeal is taken to the D.C. Circuit, it shuts down the district court proceedings pending resolution of the appeal. Now, obviously, there's a distinction between the Coinbase case and the case involved here of Donald Trump's claim for absolute presidential immunity, which was rejected. Coinbase involved arbitration, an established doctrine. As it relates to absolute presidential immunity, the D.C. Circuit Court of Appeals, in the civil context, back about 10, 15 days ago at this point, ruled Donald Trump is not entitled to it in civil cases relating the January 6th insurrection because it involved election activity, not Article 2 activity. So you think about it from Judge Chutkan's perspective, she rejected Donald Trump's claim to absolute presidential immunity in a criminal case because she said, look, the same considerations about why presidents get absolute presidential immunity or former presidents get absolute presidential immunity during things that happened while they were in office For civil cases, those considerations do not apply to criminal cases. So it's like double protection. If you think about it, you've got Judge Chutkan saying clearly the doctrine of absolute presidential immunity does not apply in criminal cases. And then you had the D.C. Circuit Court of Appeals saying even if it did apply in civil cases, which the case Nixon v. Fitzgerald acknowledges that does exist in civil cases, this case is not even those cases in the outer perimeter of presidential authority, because what transpired on January 6th and related thereto involved election activity, not Article 2 powers. There's a lot of dates getting thrown around, so I want to just help remind you of all of these different dates. So the first date to kind of point out is a minute order that was issued by the D.C. District Court Judge Tanya Chutkan when Donald Trump said, "Halt! Stop the proceedings before we filed a notice of appeal." Trump filed the notice of appeal December 7th and a motion to stay on December 7th. Judge Chutkan issued this minute order on December 7th. Minute order! As to Donald J. Trump, upon consideration of defendant Donald Trump's motion for order regarding automatic stay of proceedings pending appeal, it is hereby ordered that the government shall file any opposition to defendant's motion by 5 p.m. on Sunday, December 10th, 2023, and that defendant Donald Trump shall file any reply by 5 p.m. on Tuesday, December 12th, 2023, signed by Judge Tanya S. Chutkan. And on December 10th, Special Counsel Jack Smith said, "Look, we recognize that there is an automatic stay on interlocutory appeals under what's called the Griggs Doctrine, a case called Griggs, but that is limited in nature. It doesn't involve a full stay of all proceedings in the district court. So we're going to proceed as though the case is moving." Donald Trump, pursuant to this order by Judge Tanya Chutkan, filed his reply paper by 5 p.m., close of business on December 12th, after Special Counsel Jack Smith's moving ahead saying, "Judge, we don't think that anything about Donald Trump's notice of appeal or motion to stay should impact like a SEPA Section 6 hearing on the issue of in-camera review of substitution, so we're moving forward." And then Donald Trump filed Trump's reply in support of his motion to stay pending appeal. And then Donald Trump says that hours before initiating proceedings before the Supreme Court in order to try to complicate Trump's as-of-right appeal in the D.C. Circuit, the prosecution filed an opposition brief that ignores the Supreme Court's binding precedent and urges the court to permit continued pretrial proceedings on a parallel track. The prosecution's brief was ambiguous about what they had in mind, but today they filed a motion for SEPA Section 6, a SEPA Section 6 hearing, which the court currently lacks jurisdiction to conduct, notwithstanding the prosecution's overlapping and still pending SEPA Section 5B motion, which the court currently lacks jurisdiction to resolve, and that is a SEPA Section 5B, a response to a SEPA Section 5 request by a criminal defendant to try to introduce classified information. And here, Trump is basically saying that both of those SEPA proceedings, everything needs to be halted. And Donald Trump lists all of the existing deadlines he claims are stayed. Jack Smith saying, nope, all of the existing deadlines keep going pending the appeal, other than issues that fall squarely under Donald Trump's appeal of the ruling denying his motion to dismiss for absolute presidential immunity. So look what Donald Trump is requesting here, that all of these deadlines be stopped. Further briefing on discovery, motions for subpoenas, disclosures, expert witness disclosures, witness lists, proposed written questionnaires for jury selection, the trial. Donald Trump wants it all stopped, right? That's his go-to move. Stop everything, stop the presses, stop the trial. And then Donald Trump's trying to use that his appeal as a way to cause that delay, as Special Counsel Jack Smith is saying, nope, we are going forward. So now The issue was fully briefed before Judge Tanya Chutkan. As I mentioned, Donald Trump cites a case called Coinbase, and he also cites the case where the D.C. Circuit Court of Appeals rejected his claim of absolute presidential immunity in a civil case to claim that supports staying discovery in an underlying district court case. So we'll see what Judge Tanya Chutkan does there. It's going to be an important ruling by her. Now, a lot of dates and deadlines being thrown around. So this has now been fully briefed, the issue of whether Judge Tanya Chutkan's going to stay all district court proceedings. It's not an easy call for her. For those saying it's easy and she should reject Donald Trump's request right away, I'd like that to be the answer, but I'm not going to blow smoke your way. It's a tough one. These are new and novel issues. If you go by the Coinbase case and analogize this to arbitration provisions, the district court would be stayed. There is a portion, no matter what, of the district court proceedings that does get stayed. But will Judge Chutkan say, because absolute presidential immunity encompasses everything, all of the deadlines should be stayed because they're all impacted by this? Or will she use a scalpel and say that it is narrow? That's what she has to decide. Meanwhile, Special Counsel Jack Smith, as noted in Trump's reply paper, is doing two things. First, he went directly to the United States Supreme Court and said this is an extraordinary case that falls under the same type of doctrine as USA v. Nixon, and this is so fundamental to our democracy, Supreme Court, you need to grant certiorari and hear oral argument. In other words, hear oral argument right now, even before the D.C. Circuit Court of Appeals makes any ruling. The Supreme Court responded right away. It did not grant Special Counsel Jack Smith's request or petition for certiorari, but the Supreme Court did grant expedited briefing on the issue of whether certiorari should be granted or not. So the Supreme Court is going to hear that on an expedited basis. Trump's brief there is due December 20th. Then the Supreme Court will decide, should this go like an elevator straight to the penthouse, straight to the Supreme Court, and they decide the issue of absolute presidential immunity in this context, or do they reject it? Separately, the D.C. Circuit Court of Appeals is also weighing in because Special Counsel Jack Smith did two things. Went to the Supreme Court and said, we need you to look at this right away, and then went to the D.C. Circuit Court of Appeals and requested an expedited appeal. The D.C. Circuit Court of Appeals responded by expediting briefing, not the appeal, on whether or not to expedite the appeal. And there, a very quick turnaround was required by the D.C. Circuit Court of Appeals that by Wednesday, December 13th, 2023, Trump has to give his version or his position, rather, on whether or not there will be expedited briefing. He's going to say no, there shouldn't be because he wants to delay everything. Then there's a reply due by Special Counsel Jack Smith on December 14th. But by the end of this week and perhaps the latest early next week, we will have a briefing schedule by the D.C. Circuit Court of Appeals. There are two Biden appointees, one Reagan/George H.W. Bush appointee, all three law and order, no nonsense judges. I expect them to expedite the appeal there, but even on a super expedited basis, I expect that to go till the end of January. So maybe on an expedited briefing, you'll hear oral arguments sometime around, looking at the calendar, I don't know, January 22nd. That week, I think you will probably have oral argument if I'm making predictions here before the D.C. Circuit Court of Appeals. We'll see what the Supreme Court does as well. And then the question then becomes is, does Judge Tanya Chutkan stay her proceedings until the D.C. Circuit Court of Appeals issues their order, and then with that delay things through January as the proceedings come to a halt pending all of these other proceedings. But you see the strategy here. Jack Smith, let's go. We're treating this as though this case is ripe and that there is no stay and that or there is no stay on all the other aspects of this case. Let's go forward. And Trump saying, no, this case has stayed. We filed an appeal on the immunity issue. That stays everything. That's before the district court. Then there's the D.C. Circuit Court of Appeals proceedings. Jack Smith wants to expedite it. Trump wants to slow it down. Then there's the Supreme Court. Jack Smith's going directly to the Supreme Court saying you should hear this as a matter of certiorari directly, given the issues are so critical. And then you have a situation where Trump's going to be arguing, no, you shouldn't hear it. So a lot going on, a lot to unpack, but that's what we do here together. We unpack it all. I'm Ben Meiselas. This is the MeidasTouch Network. Hit subscribe. We're on our way to 2 million subscribers. Thanks to your support. Have an excellent day.
Thanks so much for watching. We're only a few subscribers short of 2 million subs. Please subscribe right now to the MeidasTouch YouTube channel for free and help us grow this unapologetically pro-democracy network.